In 18 months, my sister made $310,000 selling my pastries under my bakery's name with my exact branding. When I asked her to stop, she said inspiration isn't theft. When my attorney sent the federal trademark registration, she ignored it entirely. But the moment the judge saw that registration at the preliminary injunction hearing, everything collapsed. The case ended in one session. $240,000 disgorged. Permanent rebrand ordered. And the secret that shattered our family: our mother had funded the entire copycat operation from the start. My name is Rebecca Hartwell. I spent 7 years building a bakery from scratch, only to watch my sister Jessica clone the entire brand, make $310,000, and claim inspiration isn't theft. The real question isn't just how she thought she could steal my business. It's why our mother bankrolled the operation. I opened Hartwell's Bakery in February of 2017 in a 400-square-foot storefront on Maple Street with $75,000 of my own savings. I was 25 years old, sleeping on a futon in the back office, waking at 3 in the morning to proof dough. The first year I took home $11,000. By year 3, I'd expanded into the adjacent space. By year 5, I'd opened a second location, and our signature sourdough was selling 300 loaves a day. I designed the brand myself. The cursive font with the wheat stalk curling through the letter H, the ivory boxes with navy tissue paper, the gold foil sticker that every customer said felt like unwrapping a gift. That brand was everything I'd built with my own 2 hands. In 2021, my business attorney Daniel looked at our growth numbers and said 4 words that changed everything: file for federal registration. He explained that without a federally registered trademark, anyone could open a copycat bakery, and I'd have almost no legal ground to stop them. So I filed. It took 14 months, $16,000 in legal fees, and a 67-page application. But in March of 2023, the United States Patent and Trademark Office granted Hartwell's Bakery full federal protection. I framed the certificate and hung it in the kitchen. I thought that was the end of worrying about copycats. It was actually the beginning. In June of 2023, customers started asking strange questions. A woman at the pastry counter said, "I love both your locations, but the one on Elmwood has better parking." I didn't have a location on Elmwood. A regular named Margaret stopped me in the farmer's market and said, "I went to your sister's shop yesterday. She seems so nice." I didn't have a sister in the bakery business. Then my head baker Marco showed me a photo on his phone. It was a storefront with a cursive font, a wheat stalk curling through an H, ivory boxes visible through the window. The sign read Hartwell's Bakery, except Rebecca was spelled with a second C. Rebecca. Same font, same color, same everything. I drove to Elmwood that afternoon. The building was a 4-minute drive from my original location. Inside, the layout mirrored mine: white subway tile, reclaimed wood shelving, the same blue ceramic mugs we used for coffee service. And behind the counter, wearing an apron I'd designed for my staff, was my younger sister Jessica. She smiled when she saw me. "Surprise," she said. "I got inspired." I kept my voice calm. "Jessica, this is my entire brand. The font, the packaging, even the apron. You can't do this." She tilted her head. "Inspiration isn't theft, Rebecca. I'm not using your exact name. I added a letter." I mentioned the trademark. She laughed. "Trademarks are for big corporations, not bakeries. You're being dramatic." I went home that night and stared at the federal registration on my wall. I wasn't sure I wanted to fight my own sister. But then I made one phone call to a contact at the commercial leasing office, and what I learned made my stomach drop. The lease for Jessica's storefront had been co-signed and guaranteed by Linda Hartwell. Our mother, the same woman who'd told me I was throwing my life away on flour and butter, who'd belittled my business every year at Thanksgiving, had quietly bankrolled a clone of it for my sister. I didn't just have a trademark problem. I had a family war. That night I called Daniel, not as my attorney, but as the only person I knew who would understand how broken I felt. I told him about Elmwood, the font, the apron, the lease, the fact that my mother had co-signed it. There was a long pause. Then Daniel said, "Rebecca, I need you to hear this clearly. Your federal registration isn't just a piece of paper, it's a legal weapon. Jessica is already infringing, and I can shut this down before she sells another loaf. But you have to be ready, because this won't just be a legal fight, it will be a family one." I told him I was ready. I wasn't. But I didn't know that yet. 3 days later, Daniel sent a formal cease and desist letter to Jessica's shop. It was 11 pages, attached to a copy of my federal trademark certificate. The letter outlined every instance of infringement: the logo, the color scheme, the packaging, the font, the store layout. It demanded she cease all use of the Hartwell's name and branding within 10 business days. It also requested a full accounting of her revenue, because under the Lanham Act, a willful infringer can be forced to disgorge every dollar they earned. Daniel told me later he expected Jessica to panic. But she didn't panic, she didn't even respond. The 10 days passed and her bakery stayed open, every light on, every pastry case full. In week 3, I decided to confront my mother. I went to her house on a Sunday afternoon. I didn't call ahead. I found her in the garden pruning roses like she hadn't just helped my sister clone my life's work. I asked her why. She didn't deny it. She set down her shears and said, Jessica needed something of her own. You always got everything, Rebecca. The talent, the attention, the success. I just leveled the playing field. I reminded her I'd built my bakery with zero help from her. She said, exactly, you didn't need me, she did. Then she added the line that I will never forget. Besides, it's just a bakery. You can always open another one. That was the moment I knew the family I grew up with was gone, and maybe it had never really existed. By the end of the first 6 months, Jessica's bakery had pulled in over $90,000. Customers kept calling to ask if we had 2 locations now. Some left bad reviews on my actual page because they'd gone to the Elmwood shop and been disappointed. My sales dipped for the first time in 5 years. Every time I drove past that storefront, I felt a physical ache. The same sister who used to help me frost cupcakes in our parents' kitchen was now selling them under my stolen name. And our mother had handed her the keys. Daniel filed the complaint for trademark infringement, unfair competition, and deceptive trade practices in federal district court in January of 2024. The complaint named Jessica as the primary defendant and listed the Elmwood Bakery's corporate entity. What it didn't name, at least not yet, was Linda Hartwell. Daniel wanted to wait. We'll add her after discovery, he said. Let her think she's safe. Then we pull the rug. He was building a strategy, not just a case. And the centerpiece of that strategy was a motion for a preliminary injunction, a court order that would force Jessica to shut down immediately while the full trial played out. Preliminary injunctions move fast. We filed the motion on a Monday. The judge set a hearing for the following week. In the days before the hearing, Daniel's paralegal dug up financial records that I still can't fully explain how she found. She showed me a bank statement from a small business account opened in Jessica's name, with a $90,000 initial deposit that originated from Linda Hartwell's personal savings. That same account showed payments to a sign company, a supplier of ivory pastry boxes, and a graphic designer who had been paid to replicate my logo down to the exact hex code of the gold foil. Jessica hadn't just been inspired. She had taken deliberate steps with my mother's money to copy every single detail of Hartwell's bakery, and she'd done it knowing I had a federal registration because I had told her myself. That bank statement changed everything. Daniel looked at me and said, "The judge is going to see that deposit as deliberate, willful infringement. That means enhanced damages. That means all of it." I asked him what all of it looked like. He said it looked like a number that would end Jessica's business and her financial future, and my mother's too once we named her. The hearing was scheduled for 9 a.m. Thursday. On Wednesday night, I sat in my bakery after closing, staring at the framed trademark certificate on the wall. I thought about the first loaf of sourdough I ever baked here, the first customer who told me it reminded her of Paris, the 100-hour weeks and the exhaustion and the joy. And I thought about the one person who was supposed to protect me, who instead had tried to replace me. The next morning, I put on the same cream apron I'd worn on opening day, and I drove to the courthouse. I was about to watch my sister and my mother face the full weight of federal law. And what they didn't know, what they couldn't have prepared for, was that the woman presiding over our case, Judge Elena Vasquez, had already reviewed the financial exhibits. She had a reputation for zero tolerance with willful infringement, and she was about to make an example out of someone. I walked into the federal courthouse at 8:45 in the morning, wearing the same cream apron I'd worn when I signed the lease on my first storefront. Daniel met me in the lobby. He was carrying a binder that weighed at least 12 pounds, every tabbed page a nail in my sister's case. "Judge Vasquez reviewed our exhibits last night," he said. "She had questions about the bank transfer. That's a good sign. It means she's already decided this isn't a misunderstanding, it's a calculation." I asked him what kind of judge she was. He said, "The kind who starts hearings by telling both sides exactly what she thinks and then asks if anyone disagrees." No one ever does, apparently. Jessica arrived at 8:52. She was wearing a blazer I'd never seen before, something off the rack that didn't fit her shoulders right. Our mother was not with her. She told the court she had a prior engagement. A garden club luncheon. Jessica's attorney was a man named Gerald Fisk, a general practice lawyer who did wills and real estate closings. Daniel had looked him up. His entire intellectual property experience consisted of one trademark renewal for a local dry cleaner. He walked into that courtroom with a briefcase and a confident smile. That smile lasted exactly 4 minutes. Judge Vasquez entered. She was a woman in her late 50s, silver-streaked hair pulled back, reading glasses perched on her nose. She didn't say good morning. She looked at the case file and said, "I've reviewed the complaint, the motion for preliminary injunction, and the financial exhibits submitted by plaintiff's counsel. Mr. Fisk, your client is operating a bakery under the name Hartwell's, using a logo that appears substantially identical to the plaintiff's federally registered mark, correct?" Fisk stood up. "Your Honor, there are differences. The name is spelled with an additional consonant, and Judge Vasquez cut him off. Mr. Fisk, I have both logos on my screen right now. I cannot tell which is which without magnifying the image. Does your client own a federal trademark registration?" Fisk said no. "Then sit down," she said. Daniel stood. He walked the judge through the timeline. My original filing date, the 14-month review period, the registration certificate issued in March of 2023. Then the cease and desist letter sent to Jessica in June, the 10-day deadline, the complete failure to respond. He displayed the bank records, a $90,000 transfer from Linda Hartwell's personal account into Jessica's business account on May 3, 2023, 4 weeks before her bakery opened. Payments to a sign company, a packaging supplier, and a graphic designer. He showed photographs of my storefront next to hers, my pastry boxes next to hers, my gold foil sticker next to hers, identical down to the hex code. Then he said the words that silenced the room. "Your Honor, this is not a case of accidental similarity or shared family tradition. This is a calculated replication of a federally protected brand, funded by the defendant's mother, executed with full knowledge of the plaintiff's exclusive rights. Under the Lanham Act, willful infringement of a registered mark carries remedies including disgorgement of all profits, enhanced damages up to 3 times those profits, and permanent injunctive relief." Jessica's face went pale. Fisk whispered something to her. She shook her head. He whispered again, more urgently. I saw his hand reach under the table and pull out a document from his briefcase. It was a copy of my federal registration certificate, the one Daniel had attached to the complaint. Fisk had finally read it. He'd finally understood. He asked for a brief recess. In the hallway, I watched through a narrow window as Fisk spoke rapidly to Jessica. Her arms were crossed. She was shaking her head. Then her shoulders dropped. Fisk approached us. "My client is prepared to discuss settlement terms," he said. Daniel didn't smile. "Full disgorgement of revenue, 18 months back to opening. Accounting has it at $310,000. We'll accept $240 to avoid litigation on exact calculations. Plus a permanent rebrand order, destruction of all packaging and signage using the infringing marks, and a written acknowledgement of infringement signed by your client and by Linda Hartwell." Fisk said he'd take it to his client. He came back 7 minutes later. "She'll agree to the disgorgement and the rebrand, the acknowledgement she wants to limit to her own signature. Her mother isn't a party to this suit." Daniel looked at me. I shook my head. "Linda co-signed the lease. She provided the capital. She is as responsible as Jessica." Daniel told Fisk, "No acknowledgement from Linda, no deal. We'll finish the hearing and let Judge Vasquez rule on the injunction and treble damages. Your call." Fisk went back in. When the hearing resumed, Judge Vasquez asked if the parties had reached any agreement. Fisk stood slowly. "Your Honor, after reviewing the evidence more closely, my client recognizes the strength of the plaintiff's claims and wishes to enter into a settlement." He outlined the terms: $240,000 in disgorged profits, payable within 60 days, permanent injunction against use of the Hartwell's name, logo, packaging, and trade dress, and a signed acknowledgement of willful infringement from both Jessica Hartwell and Linda Hartwell. Judge Vasquez raised an eyebrow. "Ms. Hartwell, the sister," she said, "do you understand what you're agreeing to?" Jessica's voice was barely audible. "Yes, Your Honor." "And do you understand that this court has the power to enforce this order through contempt proceedings if you violate it?" "Yes, Your Honor." Judge Vasquez signed the order right there on the bench. "This court strongly encourages family members to resolve disputes before they reach my docket," she said. "But once they do, I expect full compliance." Ms. Hartwell, the plaintiff, you built something real. The law protects that. Don't let anyone tell you otherwise. I left the courthouse at 11:15 in the morning. My sister would close her bakery by end of day, never to reopen under my name. The judgment gave me the right to inspect the premises within 48 hours to ensure all infringing materials were destroyed. I exercised that right. I watched workers pull down the cursive sign, box up the ivory pastry boxes, peel the gold foil stickers off the glass display case. Jessica was not present. She'd sent an employee to handle it. The employee was an 18-year-old girl who'd worked there for 3 months and had no idea what was happening. She asked me if she was losing her job. I told her to come to my bakery the next day. I'd find her a shift. But the story doesn't end with a closed storefront and a court order. Because that $240,000 wasn't just a penalty against my sister. It was capital. And the decision I made about what to do with it would test this family in ways no courtroom ever could. I was about to offer Jessica something she didn't deserve, and her answer would reveal whether any part of our relationship could survive what she'd done. 2 weeks after the courthouse, I sat down with my accountant, my attorney Daniel, and a franchise consultant I'd hired with part of the settlement. I had $240,000 and a single question: could I turn what my sister stole into something that outlived both of us? The consultant looked at my sales data and said, Hartwell's isn't just a bakery, it's a replicable asset. You can franchise. He outlined a plan, a licensed location model where franchisees pay a percentage of revenue to operate under my brand, using my recipes, my supply chain, my training. I'd retain ownership of the trademark and final approval on every detail. It was the same model big chains used, but designed for a small batch bakery that had never lost its soul. I decided to do it. And then I made a decision that surprised everyone, including Daniel. I invited Jessica to lunch. She met me at a cafe halfway between my Maple Street location and her now-closed storefront. She looked smaller, diminished. The federal judgment had frozen her assets until the disgorgement cleared. Her credit was destroyed. She still owed my mother's $90,000 back, but Linda had stopped answering her calls. I ordered a chamomile tea. She ordered nothing. I slid a folder across the table. Inside was a licensing agreement. One location, fully rebranded, operating under the name Hartwell's by Jessica, with all signage approved by me, all recipes supplied by my kitchen, a tenth of revenue returned to me monthly, and a binding clause that any violation of the terms would trigger immediate revocation. She could work in a bakery again. She could earn a living. But she would never own my name. She'd never make a single decision I didn't approve. He'd never escape the fact that her entire livelihood would exist only because I allowed it. She read the agreement slowly. Her hands trembled, then she closed the folder. I can't do this, she said. I can't wake up every day knowing that everything I touch belongs to you. I told her it was a genuine offer, that it was more than she deserved. She pushed the folder back. You don't understand, she said. Mom told me you'd never succeed. She said you'd fail by year 3 and the brand would be worthless. She said if I took the concept and did it better, I'd prove what she always believed, that you weren't special. The trademark, the registration, the lawsuit, none of that was supposed to happen. You were supposed to give up. She stood up. I don't want your franchise. I want you to have never existed. She walked out. That was the last time I spoke to my sister. The next morning, I drove to the Elmwood storefront. The sign had been removed, the interior stripped back to drywall. The lease had reverted to the landlord after the cosigner, Linda, refused to continue guaranteeing it. I called the landlord and offered to take over the lease myself. 3 weeks later, that space became the first Hartwell's franchise, owned and operated entirely by me, serving my recipes under my name. I hired the 18-year-old employee Jessica had abandoned. I paid her $2 above minimum wage and taught her to score sourdough. Her name is Kayla. She's now my assistant manager. The irony hasn't escaped me. My sister's copycat shop, funded by my mother's bitterness, became the first expansion of the brand she tried to destroy. That location now does 20% more revenue than my original store. The customers who once couldn't tell the difference now drive past the Elmwood storefront and see a sign that says Hartwell's Bakery, registered trademark, proudly protected. The same sign my sister swore I'd never have. Linda Hartwell never apologized. She sent one text after the settlement, a short message that read, I hope you're proud of yourself. I didn't respond. She showed up once at the Elmwood location about 6 months after opening, wearing a pressed blouse and clutching a church bulletin. She asked to speak with the owner. Kayla called me. I walked out from the back, still in my apron, flour on my hands. Our mother stood in the doorway. She said, "I've come to see what you've done." I said, "Then look." She stood there for a long moment, silhouetted against the afternoon light, staring at the display case full of pastries, the line of customers, the gold foil stickers she'd once funded a copy of. Then she turned and left. I haven't seen her since. And that's when I learned the lesson that no trademark registration could ever teach me. Some people will spend their whole lives trying to shrink you down to a size they can live with. My mother thought she was protecting Jessica. She was actually revealing herself. My sister thought she was stealing my brand. She was actually handing me the proof I needed to protect it forever. Every box of ivory tissue paper, every curled wheat stalk on every sign, every loaf of sourdough that leaves my kitchens now carries a weight it didn't before. It's not just bread. It's evidence that the thing you build with your own hands can survive anything, even the people who should have loved you most. The story of Hartwell's Bakery isn't really about trademark law. It's about what happens when the people closest to you mistake your success for their loss. My mother saw my bakery and felt diminished. My sister saw my brand and felt entitled. And the legal system, for all its flaws, had a word for what they did: willful infringement. A phrase cold enough to hold them accountable when family loyalty couldn't. I still wear the same cream apron. I still proof my dough at 3 in the morning. The sign on Maple Street hasn't changed, and the Elmwood location now does more business than I ever imagined. But the most important number in this story isn't the $310,000. It's 7. 7 years I spent building something before my own family tried to take it, and 7 minutes it took Judge Vasquez to read my federal registration and decide the case was already over. If you're building something that no one in your family understands, register it. Protect it. Not because you don't trust them, but because the people who know you best are sometimes the ones most convinced they know better. My mother was wrong. I wasn't special because she said so. I was special because I showed up every morning before the sun and refused to quit. And no amount of stolen fonts or copied packaging could ever replicate that. If this story meant something to you, please take a second to like and subscribe. Drop your city and what time it is where you're listening in the comments below. I love knowing where you are. My name is Rebecca Hartwell. This was the story of how my sister cloned my bakery, my mother funded it, and the federal trademark law that shut it all down. And to anyone out there building something of their own, keep going. The law is on your side. And so am I.